Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull & Estate and Succession Planning. You're listening to episode 160 of our podcast on Tuesday, April 14th, 2009.
Hi, Suzana.
Hi, Ian.
So today we were discussing our last week's podcast was a pet peeve podcast. And this is not a pet peeve podcast, but one that I think is worth exploring. And that is a scenario where we think that some people joke with us that our practice of law can't be urgent and that nothing pressing can happen.
That's right, because everyone's dead.
That's right, exactly. But in fact, it's not true. Mm-hmm. And in fact, most of the time, we are met with a client, not most of them, many times we are met with a new client meeting where the new client comes in and wants something done urgently, wants an injunction, wants us to run to court, wants us to freeze assets, do those kinds of steps. So I thought today we'd talk a little bit about what that injunctive, what that freezing of the assets step means, and secondly, what is typically an approach that we take in situations like that. So why don't we look at, here's an easy example. Someone comes to see us, and it's a daughter, and she comes to see us and says, look, I'm terrified. My brother is using up all of Mom's money. He's buying things, he's spending it, and I don't know where it's going. I need you to I need you to stop him from spending. And the first step you could take is to, once you've verified and identified your client, as we said last week, you could take the initial steps of contacting the bank. And that is one step. Another step, and we'll talk about that step first. But first of all, let's talk about sort of the quick idea of the steps. Another is, of course, some ideas is that we could run to court and get a court order freezing him in his activity. Another idea is to do nothing. So within the framework of the various options available to us, we start with looking at the rules of civil procedure here in Ontario that talk about getting court orders. Because if that's the ultimate goal, we have to look to what is realistic. Can we achieve that ultimate goal?
And just, Ian, from a practical consideration, as much as we can do all the steps to get the court order and get the materials ready as quickly as possible, sometimes we are just, as a result of the process, at the mercy of the court system itself and their availability to hear matters on an urgent basis. And so in terms of the little bit of the rush, we can do everything that we possibly can, but there are sometimes procedural pitfalls that we come up against. And so to the extent that we can do everything on this end to get our clients in a position where they can get before a judge as quickly as possible, getting all the right information, getting as much information as possible as quickly as we can is all a precursor to being able to get a good result for them at the end of the day.
For sure. So if we're going to come looking for that kind of urgent advice, you need to come well prepared.
That's right. With
the documents, with the material that you have, or the details that you need. And one of the things that we'll typically say to a client is that, well, that's fine. We can clear our desk, so to speak, take all of the other priorities on our desk of that day and start working on your file. But urgent attention requires urgent action, requires tremendous costs, and it requires sort of an effort, an extraordinary effort to pull it together. So that's one thing, and I think the costs issue is a reality and one that has to be weighed against the risk. And what is the flight risk, so to speak? Who are we dealing with? And is there a true risk, or are there security that the money's going to leave, or are there security behind it?
And the reality is, Ian, the rules themselves speak to the possibility that the costs could become an issue at the end of the day. If you were to proceed, for instance, with trying to get some injunctive relief on an emergency basis and not necessarily be successful, a judge might criticize you for having taken those steps and award costs either against you or penalize you in some other fashion for having done so. So that's something you'll want to definitely canvass with your advisor before you decide to actually take some active steps in that area.
That's for sure. So the issue of legal costs is fundamental. Both the costs of you're paying your lawyer to clear their desk and get this relief, and secondly, of course, if you're wrong and you lose and that kind of thing. Now, then I usually ask my clients, I say, look, let's balance it against who are we dealing with and what is the flight risk? Are we dealing with a brother or a sister? Are we dealing with a friend, a neighbor? Are we dealing with someone who is known to be a flight risk, so to speak, who has international sort of dealings and maybe could take money and have it vanish and make it difficult to get? All of those assessments need to be undertaken by the client, because we don't know the other side. We can only say the safest route is to run to court and freeze the assets. So if we want to sort of break that down a little bit, in terms of an approach that can be effective and is by no means secure, is that we can sometimes write the banks. And what do you find your experiences, though, when you write the banks with those kinds of stop dealing with the account letters?
Well, oftentimes we'll be faced with the reaction of the bank being simply, nice try, but who are you to tell us what to do? And you're just a lawyer. We don't even know whether or not that authority is valid authority. And unless a judge tells us, a court order tells us to stop, we're not going to pay a lot of attention to that. And then there's also the procedural dealings within the bank itself in terms of the different layers of people that have to look at this letter before you'll even get a meaningful response. So I always warn clients that this is probably the least effective or the least guaranteed way of effectively freezing any estate assets or any assets at all, because the bank's not going to necessarily feel compelled to, just because your name's on a letter.
Well, that's a very good point. So if we're not inclined to write the letter, or write the letter and we don't get a favorable answer, and the bank says, look, it's at legal department, but the legal department's telling us you have no authority to be freezing accounts, and the bank sort of lets it sit there open. And if you don't want to proceed with contentious litigation where you're into tens of thousands of quick dollars that may not be recoverable and may be, in fact, recoverable against you, that's when you really have to take that careful look at the risk assessment. And one of the other sort of cheap ways to try to freeze estate accounts in estate situations is to file a notice of objection, because that prevents the possible party that is allegedly taking the money from getting probate. Now again, that's not a fail-safe, and all it does is prevent someone from filing and getting probate. Well, not filing, but getting probate. But it too can be an effective tool. And I find what I do in these situations is that I sort of look at the paradigm, and I start at the highest, and that is court order, subject to the Court of Appeal, but a court order freezing assets, and work your way down. Letter to, for example, letter to the banks. Sometimes it pays off, sometimes it doesn't. Letter just from a lawyer. Sometimes it pays off. Sometimes people get another lawyer, people agree that quickly, let's just freeze the accounts, take a deep breath, and see where things are going to go. Notice of objection, file the notice of objection. Getting third parties involved, such as the Office of the Public Guardian and Trustee, where there is a situation of an incapacity. So those are just little variations on the theme, with the ultimate goal, and that is, if we're going to try to stop the money flow, what steps economically, practically, and legally can I take?
And none of these steps, of course, Ian, are mutually exclusive. Like, you can do all of them, you can do some of them, you can do most of them. And it's all part and parcel of the package that you put together to provide the best possible solution that you can to your client to try to get the best possible result at the end of the day.
Absolutely. Well, that was just our thinking on what can be the urgency of death. And death doesn't get much more urgent when it deals with money.
That's for sure.
So thank you very much for joining us today.
Thanks to you, Ian.
Thanks, Suzana.
You have been listening to Hull on Estates and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you are reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.